Hi, and welcome to ProfDale's property video number 19. In the previous videos, we've been talking about tenancy in common and joint tenancy with right of survivorship. But in this video, we're introducing a new form of co-tenancy, namely the tenancy by the entirety. Now, the unique thing about a tenancy by the entirety is that it can exist only between a married couple. It raises an interesting question after the Oberfeld case. When the Supreme Court legalized same-sex marriage, the question still exists in many states whether a tenancy by the entirety can exist between a same-sex married couple or not. In all probability, the ultimate result will be yes, but it's still under litigation in many states. There are 5 unities involved in the tenancy by the entirety. This will remind you of the 4 unities for a joint tenancy with right of survivorship: time, title, interest, and possession. But in a tenancy by the entirety, there's a 5th unity, often called unity of person or unity of marriage. And what that means is that there has to be a marital unit, and the marital unit is considered to be like a single person. Tenancy by the entirety is similar to joint tenancy with right of survivorship, in that there's a right of survivorship. If one of the spouses dies in a tenancy by the entirety, the other will continue to hold the entire property. Today, tenancy by the entirety is recognized in 24 American jurisdictions. Here's the list, and if you like, you can stop the video and check to see if your state is among them. Now, as we've indicated, in order to have a valid tenancy by the entirety, the owners must be legally married at the time of the conveyance. In other words, at the time they take title to the property. If they start out owning a tenancy in common or a joint tenancy with right of survivorship and later they get married, that doesn't automatically convert their interests into tenancy by the entirety interests. They'll have to do that expressly by a new conveyance if they want a tenancy by the entirety. What wording is necessary in a conveyance to create a tenancy by the entirety? Well, let's look at several possibilities. One of them is to John and Mary Jones as tenants by the entirety. Here the intent is expressly spelled out, and there's no doubt at all that that will work, assuming that they're married, to give them a tenancy by the entirety. What if the conveyance says to John and Mary Jones, husband and wife, but it doesn't expressly state whether they're taking as tenancy by the entirety or not? Well, the answer in all probability is yes. Just identifying them as husband and wife is going to be sufficient in most of the tenancy by the entirety states to give them a tenancy by the entirety. Suppose the conveyance says just to John and Mary Jones. It doesn't expressly say that they are married. It doesn't expressly say tenants by the entirety, but in fact they are married. Again, yes, in many of the tenancy by the entirety states, probably the majority of them, the very fact that they are married will be sufficient to give them a tenancy by the entirety. Now, sometimes you get a conveyance to people who are purported to be tenants by the entirety, but in fact they're not married, and therefore they can't hold as tenants by the entirety. So what is a court supposed to do with that? Well, there are a couple of possibilities. One possibility is to construe it as a joint tenancy with right of survivorship, on the basis that that's the more similar characteristic to having a tenancy by the entirety, in that both of them have a right of survivorship. On the other hand, the court might say, well, the conveyance purports to give something that's simply invalid, so we'll go back to the presumed default co-tenancy, which is a tenancy in common, and say that that's what they receive. Now, to recapitulate, if the grantees of a deed are in fact married, in many of the tenancy by the entirety states, tenancy by the entirety is strongly presumed. What that means is that even if they're not identified in the deed as married or as receiving a tenancy by the entirety, that's what they will get. So what that means is that if you're in a tenancy by the entirety state and a grantor doesn't want a tenancy by the entirety in a conveyance to a married couple, they'd better say so expressly. They'd better exclude the possibility of a tenancy by the entirety by saying something like, to John and Mary Jones as tenants in common and not as tenants by the entirety. You've got to make it clear. Now, sometimes an individual will desire to convey property to himself or herself and their spouse as tenants by the entirety, but you've got to be very cautious about doing that, because if there's a direct conveyance from one spouse to both spouses, the unities of time and title won't be satisfied. We talked about this problem earlier in connection with a joint tenancy with right of survivorship, but the problem exists with a tenancy by the entirety as well. So what this means is that if one individual wants to make such a conveyance, they'd better convey to a straw man and have the straw man convey back to the couple instead of trying to do it directly. Management of the tenancy by the entirety property in earlier times was exclusively in the hands of the husband. He had the right to control the property. However, all of the tenancy by the entirety states have changed that, and today in all of those states, the spouses have joint or equal management and control. At a divorce, the tenancy by the entirety will become a tenancy in common unless the court orders otherwise. But of course, if you have a settlement agreement or a court order, it may very well allocate the property entirely to one spouse or the other, or have other provisions in it about who's going to own the property. So only if there's nothing said in the divorce decree or the settlement agreement, only then will the tenancy by the entirety become a tenancy in common. Now, tenancy by the entirety has a feature that isn't shared with any other form of co-tenancy, and that is that it's immune from the claims of the creditors of an individual spouse. What that means is the creditors of an individual spouse cannot attach the property, they cannot execute on it, they cannot have it sold to satisfy that individual spouse's obligations. And this applies whether the obligation is a debt or a tort. Either way, the property simply can't be reached. If the creditor is owed by both spouses, then the creditor can reach the property and have it sold. So if you have a case in which there is a debt owed, you've got to look carefully to see if it's a debt of both spouses or only one. In a tenancy by the entirety states, if only one owes the debt, then the property is simply immune. Is this protection from creditors a good rule? Well, it has both advantages and disadvantages. The good news is that it protects the marital property from irresponsible behavior by one spouse. If one spouse is a terrible driver and keeps having accidents and committing torts, or if one of the spouses incurs a lot of obligations to retailers or credit unions or finance companies, and in other ways runs up a lot of debts, the marital property is safe from the claims of the creditors of that spouse. On the other hand, from the point of view of creditors, it makes debts much harder to collect in a tenancy by the entirety state. Bear in mind that tenancy by the entirety, while often residences are held in that form, it isn't limited to residences. It applies to all kinds of real estate, commercial, agricultural, industrial, whatever they might own, and it even applies in many of the tenancy by the entirety states to personal property as well. So the result is that a creditor of one individual spouse in a tenancy by the entirety states may, as a practical matter, have no way of collecting the debt. Let's think for a few minutes about how to end a tenancy by the entirety. There are only a limited number of ways of doing that. One way is that the right of survivorship can be dissolved and the tenancy by the entirety can end if there is, as we mentioned earlier, a divorce proceeding. There, the tenancy by the entirety will become a tenancy in common unless the court's order or the parties' settlement agreement provides for some other disposition of the property. Another possibility, of course, is the death of one of the spouses. The result of that is that the surviving spouse owns all of the property by virtue of the right of survivorship. Also, it's possible that the voluntary action of both parties together can end a tenancy by the entirety, but they both have to join. One possibility is that they'll sell the property to some third party, and if both of them sign the deed, of course, both of them give up their interests, and that's the end of the tenancy by the entirety. In addition, one spouse is allowed to give a deed to the other that will end the tenancy by the entirety. In other words, each of them could convey to the other, and the grantee of such a deed will end up being the sole owner of the property. There is no right of partition in a tenancy by the entirety, so neither spouse can go to court and ask the court to divide the property geographically or to have it sold and to have the proceeds of the sale paid out to the spouses. As long as they are still married, the right of partition simply doesn't exist. The last issue we want to discuss is what happens if only one of the spouses in a tenancy by the entirety purports to enter into a conveyance. They sign a deed, for example, to a third party, or a mortgage to a bank. Well, if husband and wife own property as tenancy by the entirety, and husband alone deeds the land to X, an outsider, what does X receive? There are 4 possible answers, and they depend on the jurisdiction. In other words, the states are quite divided on this question. The majority view, the most common view, is that conveyance is simply void, it passes nothing at all, and the tenancy by the entirety continues to exist in the spouses just as it did before. In other words, there's no such thing like a severance in a joint tenancy with right of survivorship. That concept simply doesn't apply to a tenancy by the entirety. A second possibility is that if the husband makes a conveyance to an outsider, the outsider will get the husband's present right to possession, and if the property is rented out, any rents and profits that the property is generating. Only the husband's right will pass in that way, however. The wife will continue to have her rights intact. A third possibility is that the husband's right of survivorship will pass to the outsider, so that if it happens that the husband ultimately survives and the wife dies first, the outsider will end up owning the entire property. On the other hand, if the husband dies first and the wife survives, then the third party's rights would be completely ended at that point. A fourth possibility is that both of the above results will follow at the same time. In other words, the conveyance by the husband will pass both the husband's present right to possession and the husband's right of survivorship. All of the jurisdictions agree that there is no severance. The wife, in other words, still has her right of current possession and her right of survivorship no matter what the husband does. So once again, the joint tenancy concept of severance just doesn't apply to tenancies by the entirety. Well, that winds up our discussion of tenancy by the entirety. In our next video, we'll cover community property and homestead rights, and in doing so, we'll finish up our overall coverage of co-tenancies. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.